That's helpful.
Yeah. 5 minutes of tech support, everyone. Sorry about that. We're on the air, but I don't see that our camera is on. So maybe Josh could, there we are. Okay. Okay, whenever you're ready, Chair.
Okay, good evening, everybody. I'd like to call the meeting to order and welcome you to the regular meeting of the Milwaukie Planning Commission. Agendas and additional copies of staff reports are available on the city website at www.milwaukieoregon.gov. You may locate them by navigating to the community calendar where tonight's meeting page is posted. If you have not reviewed the agenda, please do. It has important information about our process this evening. I'm going to start with our land acknowledgement. The City of Milwaukie respectfully acknowledges that our community is located on ancestral homeland of the Clackamas people. In 1855, the surviving members of the Clackamas signed the Willamette Valley Treaty, also known as Kalapuko, treaty with the federal government in good faith. We offer our respect and gratitude to the indigenous people of this land. Next on our agenda is
Chair, before we move on, I would like to make a statement, if I may. Today and last week, we lost innocent people to tragedy. Whatever your views are, gun laws, social media, or mental illness, we should reflect upon ourselves to understand that life is precious and can be taken away at any time by the hands of another. Chair, I would like to take a moment of silence to reflect on the people that have lost their lives in Buffalo and Texas. As we reflect, remember the people, your partners, your parents, your friends, your animals, and especially your children. Remember, every day, tell them that you love them and let them know that they will always be beloved. Chair, if we may, take a moment of silence. Thank you, Chair.
Thank you, Commissioner Hemer. Next on the agenda is approval of the minutes for April 12th, 2022. Does anybody have any corrections to make to the meeting minutes?
Chair, Commissioner Massey.
Commissioner Massey, yes.
I have no objections to the minutes. I just want to clarify one issue. If you go to the second page under 5.1, under my comments, I asked whether staff had recommended that the applicant meet with the applicable neighborhood district association, and the response I got was no. And I asked for clarification from the staff shortly thereafter, and I got a clarification which I think is important for the whole Planning Commission to know about. This does reflect what was said in the minutes, but I just want that clarification to be known to all of the planning commissioners. Could I ask the staff maybe to clarify that response?
I'm happy to. Yep. So the clarification when asked was that, and it's standard procedure for staff to recommend that folks meet with the neighborhood association, and that was reflected in the notes from the pre-application conference. So I think when I answered that question, I thought it was something sort of more formal or more recent than that, but it is standard procedure for staff to recommend meeting with or notifying the neighborhood association. That was reflected in the notes from the pre-application conference for this application.
Thank you. I just thought that the Planning Commission would like to have that clarification. Thank you.
Commissioner Massey, are you suggesting that we amend the minutes to reflect that?
Well, I think that we have discussed that, and that will be part of the next minutes. But, you know, this actually reflects what happened in the meeting.
So with that being said, I would like to make a motion to approve the April 12th, 2022 minutes as written.
Second.
I have a motion. Is there a second?
Second.
I have a second. All those in favor?
Aye.
Aye.
I see 3 hands raised in the room and 2 on screen. All right. On all those opposed, please vote nay. Could someone confirm for me that I only have 3 commissioners at the bench, at the dais?
3. There's 3.
3. Okay, great. Thank you. Appreciate that. Okay, the meeting minutes from April 12th, 2022 have been approved. Moving on then, additional informational items from staff.
I do not have any informational items at this moment.
Okay, thank you, Laura. Audience participation. This is an opportunity to comment on items that are not on the agenda tonight. Does anyone wish to comment on an item that is not on the agenda? If so, please use the raise your hand function in Zoom, or if on the phone, dial *9 to indicate that you would like to make a comment this evening. If you are testifying, we just ask that you state your name and city of residence for the record. And I will ask staff to indicate whether or not we have members in the audience wishing to participate.
Chair Losfeld, there are folks here in the audience, but I don't see that anyone has indicated that wishing to speak at this time of the meeting. And there is no one on Zoom indicating that they would like to speak either.
Okay, thank you, Vera. Okay, now we move on to the Community Involvement Advisory Committee, the CIAC. At this point of the agenda, the Planning Commission will act as the Community Involvement Advisory Committee. I now ask that staff provide any updates.
Yes, thank you so much, Chair Losfeld. I just wanted to follow up with you all. There had been some discussions about how members of the CIAC could be more involved with the neighborhood association meetings, and we had talked about that last time. And so they had their quarterly meeting last week, and they were able to discuss having one of the CIAC members attend those quarterly meetings on a regular basis, and they're completely fine with that. And so their next meeting is on September 15th from 6 to 7:30, and then we'll have a little conversation. We'll actually have a conversation at that meeting, whether it's me or just you guys, you folks talking about what the role of the CIAC is. So it'll just be a brief little introduction to what your role is at those meetings, and I can work with you, and we'll work with Jason to coordinate that.
And I believe at our last meeting, we appointed Commissioner Casabati as our representative and Commissioner Massey as our backup or secondary.
That is correct.
Yes, and to speak on that, could you one more time repeat the time again of that meeting?
It's on September 15th from 6 to 7:30, and we'll send you the notification, just so.
I actually did RSVP for the meeting this week. I didn't make it because I double booked and had another meeting at 7 o'clock right after, but I did speak with one of the NDA chairs the following day. They called me. And yes, if we can dedicate some time onto this, because there seems to be a consensus that, like you said, there needs to be more interaction between, or more communication between the NDAs and the planning commissioners. And I know that Commissioner Hemer brought up the idea of having one commissioner commit to an NDA. And I'd like to revisit that at some point to see if we can actually do that, because I think not just those quarterly meetings, but there's a lot that happens at these the NDA meetings themselves that I think are important for us as planning commissioners to be there to listen and to answer whatever questions we can. And if we can get some clarification on what we can and can't discuss, that would also be very helpful as well for those people.
Okay. Yeah, we can talk about that. And just to clarify, so when you go to the NDA meetings, you're there as CIAC members, not planning commission members. So you're not really talking about land use specific projects. You're kind of talking about how to better communicate with the NDAs. So if there is the opportunity, if you want to, I think voluntarily go to those NDA meetings on your own, that you can do that, but you probably want to avoid getting into particulars about land use that's going on in the city currently. Like that's off limits, but you already know that.
But we can educate them on the process, because what I'm hearing is that a lot of the public has some confusion on the process of when to speak, when they can say things, when they can comment on things, what exactly is the process of the application. I mean, they want to be educated on these steps so they're more aware of it. Because that seems to be, again, they don't have enough, there's not enough out there for them to understand a lot of the things that we even discuss. Is, you know, if you don't know land use, you're going to get lost in translation. So if we can do anything about that, that would help as well.
And one of the things I know that we had we had gone back in and done some outreach for the NDAs, kind of doing this overview of land use, right? And then our next iteration of that was there's already a PowerPoint presentation that exists that I think that was used for many years, but we're going in to update that. So it's kind of this, what happens when you get a land use application? So it's very clear as to the role that the NDA plays in that process and when is the time.
Excellent.
So we can help do some of that clarifying as well. We're putting that together. We're working on it. It's on the list.
On the long list. Yeah, I got you.
Yeah.
Thank you so much, Steph.
I'm sorry, can I pipe in here, Chair?
Yes.
So I agree with everything that's been said, but I will tell you that when you go into an NDA and they know you're a planning commissioner, they're going to ask you about some land use issue. And I understand we can't discuss those things that are coming up for discussion, coming up for a vote and everything like that. But, you know, my response is not going to be no comment. It's going to be, you know, the next meeting is going to be on such and such a date of time. I urge you to join on Zoom or come to the city hall. Or if it's a past decision, I'll reiterate what the decision was in a very abbreviated format and say that the findings of approval or disapproval are a matter of public record and that kind of thing, because they're going to ask.
Yeah, and that's completely acceptable. I'm sorry.
But you know, I don't want it to be this line that we can't cross,
Sure.
Because I think that there's some gray here, and you'll just irritate the NDA if you give them some no comment answer. So,
Well, and thank you for that, Commissioner Massey, because I also want to bring up the example. So I regularly attend the Linwood NDA. In fact, I think I'm secretary now. What they will ask is, hey, is there any planning news? And when we're going through the tree and the housing and all that kind of code, right? I never gave my personal opinion of what I thought about that. But I would give them the details and then how to be able to be a public commenter in that. And the nice thing is that it reflects upon the NDA that they know that they have somebody to come and ask a question to, and that we can carry that question forward. So, for example, one of our neighbors was disturbed that a large tree was getting removed on May 13th. So he wanted to know when the tree code came into effect. And so I sent a quick note to the planning department, got the answer back, and I can relay that message back. So it is a nice thing for your NDAs to recognize a face and help support them in the questions that they have.
Okay. Laura, is there anything else?
I don't think so at the moment.
Anything else from the rest of the commissioners? I think there's just one last thing to do here, and if it hasn't happened already, an opportunity for those who are in the audience to comment back to the CIAC using the raise your hand function or *9 if you'd like to discuss a matter with the Planning Commission acting in their role. Please do so. So just give just a second or so.
Chair Losfeld, I don't see anyone here in the room indicating that they would like to speak, and no one on the attendees list and Zoom is indicating that they would like to speak.
Okay. Thank you. All right, we will then move on to our hearing item. Our first hearing item of the evening is the proposed construction of a manufacturing light industrial building at 9285 Southeast 58 Drive. The public hearing on the proposed construction of a manufacturing light industrial building and required variance at 9285 Southeast 58 Drive is called back to order. The purpose of this hearing is to consider application number VR 2021-012. The purpose of the application is to request approval for the various applications associated with the construction of a manufacturing light industrial building at 9285 Southeast 58 Drive. The applicant has the burden of proving that the application is consistent with the City of Milwaukee's zoning, subdivision ordinance, comprehensive plan, and any applicable municipal code provisions, and that the proposal conforms with all of the city's applicable criteria. I now ask that staff cite the zoning ordinance section or sections where the criteria can be found.
Milwaukie Municipal Code Title 12, Section 16, Access Management, Title 19, Section 309, Manufacturing Zone, Title 19, 600, Off-Street Parking and Loading, Title 19, 700, Public Facility Improvements, Title 19, 906, Development Review, and Title 19, 911, Variances.
Thank you, Vera. All testimony and evidence must be directed towards the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond.
Whoops.
Chair Listfeld, you're on mute.
I think the
That's odd. Can you hear me now?
There we go.
Yes.
Okay, I apologize. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes appeal to the City Council based on that issue. Failure to raise constitutional or otherwise issues related to the proposed conditions of approval with sufficient detail to allow a response precludes an action for damages in circuit court. Any party withstanding may appeal the decision of the Planning Commission to the City Council. Persons withstanding are those who have submitted written comment or testify in person or on Zoom. Conduct of our hearing tonight. At the closing of the April 12 hearing, the Commission left the record open for additional testimony to be submitted within 7 days, allowing an additional 7 days for public to comment on the additional testimony, and 7 more days for the applicant to provide any final response. No further public testimony will be taken tonight. If additional documents or evidence are otherwise provided by any party, the Commission may, if requested, allow a continuance or leave the record open to allow parties a reasonable opportunity to respond. Any such continuance or extension shall be subjected to the limitations of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. Conflict of interest. Does any member of the Planning Commission wish to abstain from this hearing? Please raise your hand. Seeing none raised, does any member of the Planning Commission wish to declare an actual or potential conflict of interest? Please raise your hand. Seeing none raised, does any member of the Planning Commission wish to report an ex parte contact? Please raise your hand. Seeing none raised, will any commissioner who has visited the site prior to this hearing, please raise your hand. Seeing all hands raised, thank you, commissioners. Did any of those commissioners who visited the site speak to anyone at the site or know anything different than what is indicated in the staff report for this application? Please raise your hand. Seeing none raised. Does any member of the audience wish to challenge the participation of a member of the Planning Commission? And I'll give just a moment.
Chair Losfeld, I don't see any indication of anyone wishing to challenge the Planning Commission's authority.
Okay, does any member of the audience wish to challenge the jurisdiction of the Planning Commission to this hearing?
Again, Chair Losfeld, no indication.
Let's proceed to the staff report.
All right, everyone, thanks. I'm going to share my screen. I have a brief presentation. Double checking everyone can see the presentation. Okay, great. Okay, good evening, everyone. Vera Coley, Senior Planner, here to present the staff report. What you see outlined here, again, this is 9285 Southeast 58th Drive. The map outlined in red are the property lines for the site. And then you see a street view of the small, almost triangular shaped site. That picture is taken from the corner of 58th and Johnson Creek Boulevard. The site is 0.08 acres. It's currently vacant, was formerly used for storage of materials for the adjacent Smith Rock business. Surrounding area consists of small industrial.
Could you adjust your mic a little bit so you're easier to hear?
I'm sorry, the microphones don't project into the room, so I will try to project more. Sorry about that. The surrounding area consists of small industrial manufacturing uses, and the Wichita Feed and Hardware store is across 58th Drive from the site. There is a residence next door to the property, and then across Johnson Creek Boulevard is the Springwater Corridor Trail. Again, this map identifies the zoning for the site, which is manufacturing, and you can see that it is surrounded by the manufacturing zone on all four sides. Across Johnson Creek Boulevard, and then on the other side of the Springwater Corridor is the R7 residential zone, which is approximately 67 or 68 feet linearly across the street from the site. Okay. Quick reminder or just a review of the proposal itself. So this is a rendering from the application. The proposal is an 1,848 square foot manufacturing building that is 2 stories. It's the part of the proposal includes full improvements on 58th Drive. So that includes sidewalk, planter strip, and on-street parking. One parking space is being proposed on the site, which is the minimum required parking on the site. A parking modification has been requested to allow for that one on-site parking space to be the accessible, the handicap accessible space that would be required, and to use then the on-street spaces for the other parking spaces that might be necessary for the business. The variances that are being requested for this, for the development include a variance requesting to reduce the minimum front yard setback to 0 feet or to right at the property line on Johnson Creek Boulevard because of a 20-foot dedication that's required on Johnson Creek Boulevard. There's also a request to reduce the width of the landscape perimeter that's around the parking lot. So the parking space triggers there's a requirement then if you are proposing parking on the site to have a perimeter landscaping area, and they are proposing to reduce the width of that perimeter from 6 feet to 3.5 feet. And then as part of the site development where there would be the access driveway, they're requesting a reduction in the spacing of that driveway from the 100 feet required to Johnson Creek Boulevard to 72 feet. That's the most that they can do to sort of balance the safety, and because the site itself is so small, the 100-foot separation is not possible because the site is smaller than the 100 feet required. Okay. An access study was submitted confirming that the proposed driveway location is safe for site distance. Then there was a confirmatory access study from an engineer submitted as well. And of course, the city engineer who is on the call, as well as our engineering tech 3 is also on the meeting to answer any questions that there might be regarding site distance or the safety of allowing the building and the distance for the driveway from the intersection with Johnson Creek Boulevard. Again, the public improvements that are required as part of the proposal, in addition to the construction on the site itself, of course, in addition to the building, the required minimum landscaping that will be on the site. The proposal also includes full public improvements on 58th Drive. And the 20-foot dedication on Johnson Creek Boulevard. So that is a 20-foot amount of land area of the property that is dedicated to the right-of-way. So that's a land area on the site that is gone or is lost from development. It makes the site itself reduces the lot from about 3,760 square feet to about 2,605 square feet as a result of that dedication. This chart is a summary of the manufacturing zone development standards, as well as how the proposal supports that or its compliance with those development standards for the manufacturing zone. So you can see that in the manufacturing zone for setbacks, the front yard setback is 20 feet. As proposed, it is 0. And again, that's because of that 20-foot dedication on Johnson Creek Boulevard. So the variance has been requested for that. The side and rear minimum setbacks in the manufacturing zone is 0. There is no minimum required, so they comply with that standard. And the street side yard is 10 feet, and they are proposing to have a 10-foot setback off of 58th Drive, so they comply with that standard as well. The building height there's a 45-foot maximum building height in the manufacturing zone. They are proposing just shy of 29 feet. So they comply with that standard. And then minimum landscaping in the manufacturing zone is 15%, and they are proposing approximately 20% on the site. So they comply with that standard as well. And this chart was in the findings submitted, but I thought it might be helpful as you work through the variance request for the application to see it graphically as part of the presentation as well. And then this chart is a graphic representation of the manufacturing zone requirements. So the outline in red that you see is the building footprint on this site without the variances. So it reflects the 20-foot setback off Johnson Creek Boulevard off of the property line, and then the 0-foot setback on the side and the rear setback that you can see as required as well. Again, graphic representation of the table that you just saw. Okay. So the key issue that staff has identified for the Planning Commission's review is the approval of variances. Would that result in any negative impacts? And are the proposed variances and the parking modification that have been requested, are those reasonable and appropriate? As part of the findings and as part of the staff report, staff has not identified any negative impacts from the application. This is a very small and constrained site, and made more so by the dedication requirement on 58th Drive. Given the proposed improvements to the site, including the frontage improvements that are required as part of the application, there is of course, the minimum site vegetation is being complied with, but they are requesting some reductions again in that perimeter landscaping to be able to accommodate the parking space on the site, while still providing that planted buffer between the parking space and the adjacent property. Staff believes that granting the variances is reasonable and appropriate, again, for a small and kind of uniquely shaped and constrained site. Okay. The approval criteria for the variance, and we've gone over these before. I just wanted to remind everyone the approval criteria again, that the applicant is elected to use the discretionary relief criteria to be reviewed for the project. So they have an alternatives analysis that provides an analysis of the impacts and benefits of the variance proposals. And that the proposed variances are determined by the Planning Commission, to be reasonable and appropriate, and that the variances meet one or more of the following criteria. So there are 3 criteria here, and they need to meet one of them, or at least one of them. So that the variance avoids or minimizes impacts to surrounding properties, that the variance has desirable public benefits, and that the variance responds to the existing built or natural environment in a creative and sensitive manner. So those are the approval criteria that we'll be using, or that we are using, to review the various variance requests. And again, also that the impacts from the proposed variance will be mitigated to the extent practicable. So those are the measurements, or that's what we're using to evaluate each of the variance requests. Again, that the 0-foot setback, the width of the perimeter landscaping around the parking space, and then the distance of the driveway from the intersection to Johnson Creek Boulevard and from the neighboring and from the adjacent property line. Comments received, and again, we went through sort of the 777 process that we've done before to allow for additional and final written testimony on the application. So the first deadline for written testimony was April 19th, and we received email testimony from Robert Van Creveld in opposition to the project. We also received written testimony from attorney Michael Connors, and this was in your packet. And Attorney Connors talked about having requested the continuation at the time at the hearing on the 12th to be able to review some of the additional material that the applicant submitted that day, including a traffic analysis regarding the site distance and the safety of the 0-foot setback and the spacing of the driveway. And Attorney Connors did include in that letter that there was not enough time to review that additional material that had been submitted. He included a summary of previous comments in that letter, and then he also included a paragraph of a few comments about the February 22nd email thread that the applicant's representative and engineering staff had with Clackamas County engineering staff regarding the proposed improvements or the future improvements of Johnson Creek Boulevard. Now, the April 26th testimony would have been for anyone to submit written comments on what was submitted on April 19th. The applicant included testimony related to Attorney Connors' summary, and because there was no new evidence, there were no new arguments presented in Attorney Connors' letter on April 19th, that information is excluded from the public record. However, there is a paragraph in the applicant's letter that relates specifically to Attorney Connors' comments on the Clackamas County emails with the county engineering staff. So that paragraph, that testimony related to those Clackamas County email testimony, that is included in the record. So that's one paragraph that's towards the end of the applicant's letter dated April 26th. And then finally, part of the comment received this package of this timeline was the applicant's final written argument that was submitted and received by the planning department on May 3rd by the deadline, and that was included in your packet. That is a summary of the prior testimony and arguments that they have made during this process, and summarizes their argument that the project complies with or meets the approval criteria for the various variances that have been requested. The staff recommendation remains that the Planning Commission approve the variances and adopt the recommended findings and conditions of approval that were made part of your packet. You have some decision-making options. You can vote to approve the application with the recommended findings and conditions of approval. Again, that is the staff recommendation. You can approve the application with modified findings, and we would need to read those findings into the record or any modified conditions of approval. You could deny the application with new findings of denial, and we will need to prepare those as part of that process, or you could continue the hearing. I think that's my last slide, so I am happy to answer any questions that you might have. And maybe what I'll do right now is just stop sharing, but if we need to go back to a slide, I'm happy to do so.
Thank you, Vera. Are there members of the commission who wish to ask clarifying questions of staff? If so, please raise your hand or speak if you're at the dais. Okay, Vera, I appreciate you covering that summary for us once again. This is an opportunity now. We're going to move into testimony. It was mentioned, Vera, but for the process here, let's say it once again. Have we received any correspondence on this matter other than those items included in the meeting packet this evening?
We have not, no.
Okay, thank you. Applicant testimony. Would the applicant or their representative like to make comment? If so, the applicant should please state your name and city of residence for the record. I'll give you just a moment. And Vera, do we have anyone from the applicant wishing to speak that you're aware of?
Yes, we do. We have the applicant's planning consultant representative here at the table.
Great. Please state your name and city of residence.
Robert Price, Portland, Oregon.
Thank you. Go ahead.
I'm not really sure who to look at while I'm doing this, so I'm just going to look out the window while I talk. We have a procedural issue to raise, first of all. In the April 12th meeting, the property owners, Carol and Keith Phelps, spoke about their comments and discussions with Lou Smith, and that was not reflected in the minutes. And that's a problem, I believe. If it's not reflected in the minutes, it doesn't give the Planning Commission a complete picture of the case. And we think that if that's the case, then we've got a procedural flaw here that needs to be corrected somewhere along the line, probably before they make a decision.
I would have to go back and listen to the recording to see if there's actually something that needs to be fixed in the meeting minutes. So I can't confirm,
Yeah.
I wasn't here at the
No.
meeting myself, so I apologize. I
Right.
was absent for that meeting.
Please do, but it'll be on the recorded minutes, and Carol and Keith Phelps were speaking and were attending that meeting by video.
Sure, I will go back and we will clarify
So
that, Eric.
until you clarify that, I don't think a decision can be made.
Well, most of the commissioners that were here that night, you all were here, you were at the meeting.
I guess I'm confused. You're saying that the applicant and Mr. Smith had a conversation during the meeting?
Not during the meeting, prior to the meeting. The applicants have owned the property for over 15 years and have worked with Mr. Smith while he used the property. He traversed across the property with vehicles. They offered to develop the property for him, and he declined. They had numerous discussions over 15 years with him about the future of this property.
That hasn't been reflected, that didn't happen during the meeting, so it wouldn't be reflected in the meeting minutes.
But I, from my recollection, if I do, that the applicants did bring up the conversation, or that they have talked to Mr. Smith over a vast amount of time, and that they had rented the property, that Mr. Smith had rented the property from them for 15 years or something like that, and that they had been in discussions with that. Yeah, so the minutes wouldn't, unless if Mr. Smith submitted some sort of public testimony to that point, then I guess it would never reflect in our minutes of a prior conversation. But I do remember them, the applicant, talking about that.
Yeah. And that's fine, but it's my opinion, I'm not an attorney, it's just my opinion, that your staff needs to go back and listen to that tape and to make sure that is recorded as part of the information, because if this was ever appealed and somebody listens to the tape, they're not going to hear that.
We can remedy it for the meeting minutes for next time. We can do that.
Great.
That's fine, no problems.
So
Absolutely.
I don't know, my own question is, how can you proceed?
And correct me if I'm wrong, Justin, I believe that the commissioners that were here, the meeting minutes are not part of the official record. So therefore, the meeting minutes aren't necessary to be correct in order to proceed, is my understanding.
I'll let the city attorney,
The city attorney's
Mr.
here,
Prince,
so-
he can speak to this.
Can you hear me?
Yes.
Yes.
Yeah, I think we could take notice of the fact that's not certain whether it should have been reflected in the minutes, but we could take notice of that fact for the purposes of the record this evening. And we could check back on the record. I don't recall that testimony as I sit here today. And I have not listened to the last hearing in preparation for this to be able to confirm that, but we can review that. I believe it was also stated in the final written argument from the applicant as well. Is that correct?
It may have been.
I believe it is, so it will be reflected in the record. The minutes, of course, don't. I'm sorry, I'm trying to page through. My recollection in reading through your final written argument was that fact was reflected in the final written argument.
I'm sorry to interrupt, Justin. Yes, that testimony is reflected in the paragraph at the top of page 4 of the final written argument. So the applicant has reflected that testimony in their final written argument. I do recall Mrs. Phelps making comments during the hearing about that. So the final written argument accurately reflects what she testified to. What it's not, but the specifics of her comments are not reflected in the minutes. So I think we just need to understand, can we proceed reflecting that we will need to amend the minutes, but the record is still intact as far as moving forward with the hearing. That's what I think, what I want to understand. I think what Mr. Price wants to understand.
Right, and I believe that's correct. I think we can continue to move forward, given that it's in the record reflected in the final written argument, and we can correct the minutes to so reflect.
I don't know how this could have happened. I mean, how could the minutes have skipped over the testimony of the property owner on a major issue? I don't understand how that can happen. And I think it demeans our case by not having a full understanding of what the property owners had to say.
I don't think it was intentional. It was just an oversight.
No.
So I apologize for that.
No.
The person who recorded the minutes, he wasn't here, so he watches the meeting and then records the minutes. And usually he's really, really good. And for some reason, this time he just inadvertently missed that. And my sincere apologies about that.
Yeah, and unfortunately, it happened to us. You know, it could have happened to somebody else, but unfortunately, it happened to us.
Right.
And we think it demeans our case.
Well, I think, as Justin said, the comments are actually captured in the record. So therefore, it is part of the public record.
He also said he didn't recall the testimony.
Well, it's in the record, though. So that,
Well,
I apologize.
I don't think this reflects well here, but whatever.
Well, may I ask what relief then you would seek that we provide you if you don't feel it? Should we correct the minutes, continue the hearing, and set it for another date certain when the minutes will reflect that testimony?
Well, I think we strung this thing out for quite a ways, and I'm not sure we've got much more time left on the calendar. I mean, the 180 days, you know. We had originally tried to get the applicants to submit something in writing, and that was not accepted. So there was nothing to reflect what the applicants said. Just our little paragraph on the top of page 4. But we had presumed that her testimony was recorded and could be listened to or reflected accurately in the minutes, and neither of that has happened. None of that has happened.
And it is recorded, and it is on the website, so people can watch it on the website.
Yeah, the YouTube hearing is available and it's always available.
Well, city attorney, I don't know. I'm not sure what to do. What is your suggestion as a city attorney?
Well, my suggestion is what Vera Colias and I suggested a few moments ago. That testimony is reflected in the record via the video, which will be part of the record. That, as you point out, if this should be appealed, the video is part of the record. So we can correct the minutes. That testimony is also reflected in your final written argument. I don't think any of the planning commissioners present here today are doubting that testimony exists. And so I think we can continue with the hearing.
We're not doubting that it exists either. We just want to see it brought forward.
I think we're acknowledging that testimony exists, and we can amend the minutes to reflect that.
City Attorney, I'm seeing that we have a commissioner with his hands raised. So Commissioner Sherman, do you have a question?
I was just going to say I'd be willing to make a motion to amend the minutes. I think 2.1, page 3, near the bottom, it says this is of the April 12th minutes that we previously approved. Commissioner Casarabati asked whether there was a communication between the applicant team and the adjacent property owners. The applicant team responded that they have not communicated with any adjacent property owners. I think we could add a comma, but they had communicated with Mr. Lou Smith. I'd be happy to read that into the record and make a motion there if that would be amenable to everybody.
I think that is amenable. I think if, Justin, if you would agree. You're on mute, sir.
I'm sorry, we have a procedural objection, I believe. Attorney Connors has raised his hand. Let's entertain his procedural objection.
Okay, Attorney Connors, I've allowed you to talk, so you should be able to make your comments.
Okay, thank you. Can everybody hear me?
Yes. Please state your name and city of residence for the record.
Name is Mike Connors with the law firm Hathaway Larson. City of residence is Portland, Oregon. The reason I'm raising this is there's a couple of different procedural issues that I think this new testimony has created. First of all, at the last hearing, the Planning Commission did not continue the hearing. That's what we were hoping that was going to happen, but we understand that the Planning Commission has the discretion to just leave the record open, which is what you chose to do. So the record should have closed, or did close by statute at that second rebuttal letter phase. The closing argument was to be argument only. There was supposed to be no testimony tonight. You were just supposed to deliberate and make a decision. And now we have the applicant interjecting new evidence that I can say, I don't recall the specifics that he's talking about. I listened, I was in that hearing, and I don't recall the specific that he's talked about. And now he's introducing new evidence when the record has already been closed. I don't have an opportunity to even talk to my client to figure out whether what he's representing is accurate or not. So I think there is a bigger procedural issue, and that is the applicant has opened the record when the record should have been closed, and now all parties should be entitled to an opportunity to respond to that testimony. I don't believe you can amend the minutes. I don't believe you can take verbal testimony at this point because that's new evidence. It should have been a closed record deliberation and decision. So on that basis, I would argue that I believe that the city does have to continue the hearing. And I apologize for that, but it's the applicant that created this issue. And lastly, I will say to the comments about the testimony being reflected in the written closing argument, the closing argument is not permitted to contain any new evidence. So to the extent the commission would be relying on evidence or testimony in the closing argument, that would be a procedural error. So that's something I just wanted to bring to your attention. I presume showing up at this hearing, there was just going to be no testimony, deliberations, and a decision. But now that the applicant has interjected new information, I think you have to continue. And that concludes my objection. I appreciate you providing me the opportunity to raise that issue.
Thank you, Mr. Connors. City Attorney?
Perhaps let's take a 10-minute break so I can confer with staff, please.
Okay. We are going to take a 10-minute break. Request that everyone back in attendance at 7:34.
Okay, Chair Lisfeld, can you hear me?
Yes, I can hear you.
Okay, we're back on the air. I was, if I may, I'm sorry, I was trying to message Mike Connors about our proposed schedule, so I think we'll just need to work through this, continue what we're talking about, and have him maybe chime in just to make sure it works. I have spoken with the applicant. So,
Mr. Connors, are you still online? It appears you're on mute.
Yes, I am online. I guess I'm a little bit confused as to what the process is for tonight still, and what the proposal is to address my procedural objection. What I had understood before the applicant started testifying was that you were going to take, the planning commission was going to take testimony from parties. And so I wasn't sure if I misunderstood or misheard that. But that's one issue because, again, I presume that since this was a post-hearing process, there would be no new evidence, no new testimony. And so that was one thing that I think we need to clarify.
Yes, and I think staff is ready to respond. So, Vera, could you summarize the proposal and timeline?
yes. So in order to remedy the procedural objection, we will be continuing this hearing to June 28th. And there will be no additional testimony on June 28th, but for any clarifying questions, but no testimony would be taken at that hearing. Instead, we will be doing our 777 procedure again, whereas in 7 days, May 31st, by close of business, 5 p.m., anyone may submit written testimony that focuses only on this new evidence that was presented today at this hearing. So that's specific to the comments about Mrs. Phelps' comments at the April 12th hearing. So that's the new evidence that has been objected to. And so that is what the response written testimony due on May 31st by 5 p.m. must be limited to. Then we will post any of those comments just like we did the last round. We would post any of that by 5 p.m. on June 7th, so 7 days from then. Any response to those comments would be due. And then finally on June 14th, the applicant would have another opportunity, unless they wish to waive this opportunity, to provide a final written argument. But again, no new evidence can be submitted in that final written argument. So that is our proposal. I am sorry, through the chair, Mr. Connors has his hand raised, and I'm not sure if that's a new hand raised or the same hand raised.
I believe it's the same hand raised. Mr. Connors, if you could lower your hand or...
Can anybody hear me?
Yes.
So I'm sorry, I did have it automatically on, so I'm sorry about that. But I did want to just comment on the proposal because I guess what I'm not sure of, and again, I'm not trying to be difficult, but I just kind of want to try to explain something to the commission. I don't know why we would do another post-hearing process here where the applicant basically would get an opportunity for rebuttal and then an opportunity for closing argument. They were the ones that attempted to interject this new issue, violated the rule that this should be a closed record. What I think would be a fairer thing to do is provide both parties an opportunity to submit written testimony on this issue alone at the same time. Because, again, part of the concern that we had was the first continuance that the applicant had, they had 2.5 months to respond to everything they heard in the hearing. And they literally waited to submit some of their documents until the day of the hearing. And that's what prompted us to request that there be a second continuance so we had time. And because we only had that 1 week period, I tried to get a traffic engineer and I just couldn't find somebody that had sufficient time to do it. So what I don't want to do is be in another situation where we're at disadvantage of this post-hearing record. And I guess the last thing I would say is that I would ask if the Planning Commission would be able to indulge allowing 14 days rather than 7 because I have plans to be traveling to see my daughter at school to help her move out. And that's going to eat up about 4 to 5 days of my time period. With that, I'll concede the floor, and I appreciate you giving me another chance to address that.
This is Justin, City Attorney. I think that's a reasonable solution, Mr. Connors. Will eliminate back and forth and will allow both parties an opportunity to comment on this particular evidence for the record. Is the applicant present? Is the applicant amenable to that briefing process? It's a pretty small issue, so I think rather than go back and forth about it, we could just submit it.
The applicant's representative is coming to the dais. If I could, just for clarification, just want to understand that what the proposal is to not do the May 31st separate thing and then the June 7th, response, that the proposal is to combine those, that any response to tonight's new evidence is all due on June 7th. Do I have that correct? Is that the 14 days that we're talking about?
I believe that's correct. I'm also amenable to allowing it be 14 days, as Mr. Connors suggested.
Well, yeah, that's what I want to understand the dates, because we're still trying to meet that June 28th hearing date. So we can't, I'm just trying to understand that part of it.
I'm not sure if that question was directed at me, but if it was, yes, that is what I was requesting, what you just described, Vera.
Thank you.
Appreciate that.
Okay, and Chair, the applicant's representative is at the microphone, I presume to speak to this new proposal.
Yeah, the applicants agreed to it. Now, the fact that I'm out of town on June 28th apparently is meaningless. Is that correct? I mean, Mike asked for something different because he's out of town, but that's all right. Our consultant team will be here, even though I may not.
It's not meaningless. It's not meaningless. I was unaware that you were out of town on the 28th of June. Vera, is there another date certain that we could schedule this?
And I do, if I may, I do apologize. I was told by your applicant team that that it would work on June 28th. So my apologies. The hearing after that would be July 12th. So.
The 28th of June is fine. Just because I won't be here, we'll just bypass that, and our other team members will be here. So the 28th is fine.
Thank you for the clarification.
Okay, so if I may, through the chair, I just want to summarize one more time that the continued hearing is to June 28th. All parties have the ability to submit a response to the new evidence in 14 days, so that's June 7th. But I guess I just want to understand is that there is still, I just want to confirm that there is still the ability to submit a final written argument or the applicant's response to any of Attorney Connor's response by June 14th. Is that
No.
second? No, there's no. Okay.
I think the proposal is that both parties have 14 days to submit evidence solely on the issue of communications between the applicant and, I'm forgetting the name.
Mrs. Phelps and
Phelps.
Mr. Smith. Okay. Yep.
Right.
Okay.
And that's the only submittal, will be those two.
Okay. So nothing beyond June 7th.
Nothing,
That's it.
nothing beyond that.
Got it.
That's fine.
Okay.
Okay, Vera, then Laura, I should then close the hearing. How would you?
We need a motion to continue the hearing
Okay,
to date certain.
I'd like to
Okay.
make a motion to continue the hearing to a date certain, with all parties agreeing to what we had discussed before, to June 28th.
I second.
it has been motioned and seconded. All those in favor? Aye.
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 All in favor? All right. Thank you very much. We will continue the hearing on June 28th. right, Justin, I'll be reading then. I'll just go directly to the next hearing. Okay, Vera, are you there?
I am, yes.
So we're moving on to 6.2. And 6.2, request to modify conditions of approval for MHS at 2301 Southeast Willard Street. CSU-2017-007 at Milwaukie High School is called to order. The purpose of this hearing is to consider application number CSU-2022-003. The purpose of the application is to request the modification of a condition of approval related to the right-of-way dedication for Adams Street. The applicant has the burden of proving that the application is consistent with the City of Milwaukee's zoning subdivision ordinance, comprehensive plan, and any applicable municipal code provision, and that the proposal conforms with all City of Milwaukie applicable criteria. I now ask that staff cite the zoning ordinance sections where the criteria can be found.
Thank you, Chair Lisbell. This is Brett Calver, Senior Planner with the City of Milwaukie. The two code sections that relate to this application are Milwaukie Municipal Code Section 19.904, Community Service Uses, and Section 19.1006, Type 3 Review.
Thank you very much. All testimony and evidence must be directed toward the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes appeal to the City Council based on that issue. Failure to raise constitutional or otherwise related or proposed conditions of approval with sufficient detail to allow response precludes an action for damage in circuit court. Any party withstanding may appeal the decision of the Planning Commission to the City Council. Persons withstanding are those who have submitted or written comment or testify in person or via Zoom. If you are here to testify, please remember to confine your remarks to the application and the relevant criteria and to avoid repetition and not relevant information. If additional documents or evidence are provided by any party, the commission may, if required, allow a continuance or leave the record open to allow parties a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitation of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. Conflicts of interest. Does any member of the Planning Commission wish to abstain from this hearing? Please raise your hand. I cannot see the dais. I just need someone to speak up. There we go.
No hands raised.
No hands raised. Thank you. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest? Please raise your hand. No hands raised. Does any member of the Planning Commission wish to report any ex parte contacts? Please raise your hand. No hands raised. Will any commissioner who has visited the site prior to this hearing, please raise your hand. Seeing all hands raised. Thank you, commissioners. Did any commissioners who have visited the site speak to anyone at the site or know anything different than what is identified in the staff report for this application? Please raise your hand. Seeing no hands raised. Does any member of the audience wish to challenge the participation of a member of the Planning Commission? If so, please use *9 or raise your hand via Zoom. I'll give a moment. Moving on, jurisdictional issues. Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter? If so, please speak up, raise your hand. Seeing nothing, I will like to ask staff to provide their presentation.
All right, thank you, Chair. Planning Commissioners, good evening. Again, Brett Kelver with the City of Milwaukee Planning Office. I am going to share my screen for presentation here. All right, so this matter before you tonight has file number CSU 2022-003. It's addressing another community service use application for the fairly recent major renovation of the Milwaukie High School campus that was processed in 2017, 2018. So you may remember that project had several significant components. It involved complete demolition of the main classroom building and reconstruction of a new building, construction of a couple new parking lots. So there were a lot of moving parts to this. And as the school district, as the applicant began kind of working with staff to check off the different conditions of approval that were attached to this, one of them raised its head as needing potentially a change. And that's something that staff can't, we can't alter a condition of approval that was approved by the Planning Commission. So we're back here to present that matter to you. It's, as I'll explain here momentarily, it's essentially, we view it as kind of just a technicality, a technical kind of adjustment. And in red, this is the area of focus here. It relates to that area kind of the campus between Adams Street and that portion of 23rd Avenue that extends south from Washington Street. This area functions as kind of a turnaround, kind of a parking turnaround area for the school. There were a number of conditions of approval from this decision that related to various right-of-way dedications and vacations of right-of-way. So the project overall allowed the city and the school district to kind of clean up some issues with right-of-way that have been present on the site for a long time. And the condition I've got circled here, condition 5D, was related to a requirement to dedicate a 25-foot wide strip of right-of-way across that portion of the campus to provide for a future connection of Adams Street to 23rd Avenue. Now, the intention with that condition was, even though right now there's some topography and grade change issues, obviously that portion of the site is currently being used for parking and part of this turnaround area. I'll show in red, this is the more or less the 25-foot wide strip that would have been dedicated to allow for the potential if the high school campus were to redevelop yet again in the future, or another nearby property were to redevelop. The idea was to allow for a possible street connection between Adams and 23rd. In consultation with the current city engineer, Steve Adams, who's here tonight as well, his assessment was that wasn't practical or really necessary for what the city would like to achieve, that is to provide and preserve the possibility for some kind of potential bicycle pedestrian, primarily, connection in the future. And that's why the request tonight is to simply alter that condition that required right-of-way dedication and revise it to reflect a requirement to simply provide a public easement, a public access easement across that same area, so that in the future we would have the opportunity to make that connection if it became practical. I think some of the trade-offs that were mentioned in the staff report, or some of the pros for this, as you're aware, once the city receives right-of-way in a dedication, we become technically responsible for it and liable for it. And that was one of the city engineer's arguments, was that we can achieve what we need to without accepting maintenance responsibility and liability for what may be the continued use of this portion of the school campus by the school for a long time. So that's the suggestion to get done what we need to get done with an easement. As was addressed in the findings, this feels like a lot of process. It's kind of technically a major or a modification for community service use. We do have to kind of walk back through the 5 criteria. In the findings, I tried to take what I thought was a reasonable light touch for this. I mean, there are a few of these criteria that were worth discussing, and they're noted in the findings. Essentially, the conclusion is that the relevant criteria for approval are met, and we're continuing to preserve an opportunity for pedestrian connection, a walkway connection in that area if conditions become right. We continue to maintain the public benefit, and by changing it from a dedication to an easement, we alleviate some of the potential negative impacts of that. So in essence, the staff recommendation was to approve this, the condition modification as we suggested. In conclusion, you've got the standard suite of options here. You'll note that these just focus on findings and the recommended findings because there were no proposed conditions of approval. The findings are all about modifying a condition from a past recommendation or past decision. So the suggestion is, the recommendation from staff is to approve the recommended findings. You obviously have the option, if you'd like, through your discussion, to make some modifications to those findings. We'll just need to capture those. If you feel like you need more time, we can continue the hearing, or if you want to deny the application, we'll need some points to consider for revising the findings accordingly. So with that, I will ask if there are any questions of the commissioners right now.
Do members of the commission have any questions for staff? If so, please raise your hand. And if I could see the dais, please.
No hands raised.
No hands raised. Thank you. Thank you, Brett. I appreciate it.
Okay, and I'll just say thank you, Steve Adams, as city engineer, technically the applicant. He is here at the meeting. If he wants the opportunity to make an applicant presentation or needs to answer any questions from me, he should be available for that as well.
I do have a question for you, Steve. Related to the fee in lieu of construction on the stair that was paid, I would like to understand, because the stair and the pedestrian connection was an element of the original application, providing pedestrian access to the high school through that roadway. And I understand that it's been deemed as though it's a physical challenge for whatever reason. Is there an opportunity or an avenue in which the stair that was originally presented to be part of this development is actualized?
I can explain how we got to this place. So in summer 2019, 2020, when the construction was going on, I think it was 2019, they were actually building this. The location for the stair was to have come off of the upper turnaround area. It was going to head north to a landing, then turn back south to the lower. So it was going to drop students and pedestrians off near the south edge of the Adams Street right away, where they could then walk down to the sidewalk and access the marketplace, or also to access the Academy of the Arts, which is on 21st, as we all know. And starting construction, they actually cut a hole through the concrete retaining wall. They found our 12-inch water main several feet higher than what was anticipated, and the water main would have been part of the stairwell. And the public works director did not want the water main to become part of a stairwell. So we tried to flip the stairs going the opposite direction, but then people exited the stairs right in the middle of Adams Street, pretty much where the roadway center line was. And the school district wasn't very excited of people walking out to the middle of a road right-of-way. At that point, there's such a great difference. It's at least 6 feet between the turnaround and Adams Street, that students already use a walking path that leads them down to the Academy of the Arts. Other students use 23rd to Lake to walk down to the food cart area. It didn't seem to be a reasonable solution to direct people to the middle of a street right of way without the city then reconfiguring and doing things to change the right of way to make it more pedestrian friendly. So we decided to pull out of the decision to make a stairwell and leave it as is. If the stairwell had been made and the right of way dedication is required, we would be illegal. The PROAG, which is the public right of way accessibility guidelines, are different from ADA requirements on private land. And to create a stairwell between what would be the Adams Street dedication and not provide an adequate means for ADA access, we would have been illegal. So it was just as well that we made the decision to abandon the stairwell and not go after the right of way. And right now, I'm fine with retaining the option of sometime in the future, making a pedestrian connection there if we choose to. The right-of-way dedication didn't make sense because of the building on the north side of the 25-foot right-of-way, which could only be dedicated if someone wanted to rebuild that, tear down that building and rebuild another one. I didn't see that as a likely. And the pedestrian connection may or may never go in there. I mean, we have so many projects around the city where we need to place our dollars at. It didn't make sense to make a pedestrian connection that either conflicted with our water main or drops people off in the middle of the street.
So the fee in lieu of will never likely go into a situation where it's benefiting that pedestrian access. It goes into a general fund and it's not applied to the project.
It's not applied to the project and it doesn't quite go into a general fund. Fee in lieu goes into an NDA specific fund. So this is historic Milwaukie, and the way the code is written, the FELOC needs to be spent within the NDA it is generated in. It could be used for any type purpose to improve ped connectivity in the historic Milwaukie area. So if we want to do sidewalk improvements somewhere else that we find is needed, we can use it there. The funds have not been spent to date, so they would be available. Again, with the impacts to the school is not in favor of this connection. And I agreed with them that we weren't getting what we really wanted here.
Okay. Are there any other members of the Planning Commission who have a question for CIAC staff? Assuming not, I can't see the dais, so I'm assuming silence is.
No hands raised.
Thank you.
Good.
Staff, have we received any additional correspondence on the matter other than those presented?
No, we have not.
Okay. Would the applicant like to comment?
No, I am fine.
Do we have any questions for the commission for the applicant? Audience participation and testimony. Do we have anyone who wishes to testify on the application? And if so, please state your name and residence. I'll give you just a moment. Seeing that we have no testimony, there is no need for rebuttal. The public testimony portion of this hearing, CSU-2022-003 for 2301 Southeast Willard Street, is now closed. Is the commission ready for discussion? There we go. Seeing some heads nodding. Okay, thank you. Who would like to start?
Sure, if I may, this is Commissioner Hemer. Yeah, you know, I certainly remember the sign. I semi-remember the baseball / softball field thing. I think I was on the commission when we did the high school. I don't ever remember this ever being an issue or a topic of conversation or anything that ever really came up that caused great concern or great desire from the public to be carried on. It seems to me that because we either had, the city engineer either really has bad diagrams of his pipes or doesn't know where his pipes are actually at in the ground, it may cause an issue for this. So what I believe is that I think this is a win-win for everybody, and I hope that those funds I get that were paid to the city for Historic Milwaukie are happily accepted, and a great project comes out of it.
I will entertain a motion. Commissioner Sherman.
Sure, I'll make the motion. I move to approve file application CSU-2022-003.
I have a motion. Do I have a second?
I second.
It has been motioned and seconded. All those in favor, please state aye or raise your hand.
Aye.
Aye.
Aye. All are in favor. All right. Thank you. We have approved. CSU-2022-003 has been approved. Appeal rights. If anyone wishes to appeal the decision of the city to the city council, you can complete an application stating the grounds for your appeal in 15 days of mailing or notice of decision. Please see planning staff for details. Thank you, everybody.
Thank you, Commissioner.
Thank you, Steve. Thank you, Brett.
Appreciate it.
Have a great night. Other business? Do any commissioners have other business? I can't see the dais, so
No hands raised.
thank you. All right, Planning Commission, do we have any other items for discussion?
Chair Losfeld, if I could bring up something, if the commission doesn't have any other items to bring up.
I'll have one, but I'm happy to always go after you.
So I just wanted to say that now that the weather is getting a little bit better, and Justin and I have been talking, and we met with Commissioner Hemer, and we're hoping that over the summer we can take some time to meet with all of the planning commissioners individually to kind of talk about the role of the planning commission and see if there's any questions that you all have for us. We just want to always be a resource if there's anything you want to know, and vice versa, so we can have this two-way street of communication. So I just wanted to put that out there for all of you all, that we'll be reaching out to you so that we can hopefully get together just for an hour meeting, casual, have a conversation.
Nice.
So just putting that out there.
And I would like to remind the commissioners that this is your opportunity to clear up any fog that you may have inside your head about what we're supposed to be doing here, any questions that you may have about what rules we're allowed to use and what we're not allowed to use. And be advised that you can bring up old examples of things that we have done, not things that we're currently working on, but old examples that we have done in the past to help raise, those questions, to help you clarify. So, when they invite you, it's a really good time. Justin and Laura are great people to hang out with. They're very open and honest, and you don't get a lot of governmentese from them. You may get a little bit, but not a lot. And they are willing to be honest with the questions that you have. And it's meant to help all of us. It's really meant to help all of us.
Thank you for that offer. Appreciate that. And we'll look forward to those invites.
Chair, could I have a moment?
Of course.
Yeah.
I assume that's Chair Macy.
It is,
okay.
yes.
Or Commissioner Macy.
Yeah. Individually? Is that what I heard?
Individually. Mm-hmm.
Why wouldn't we meet all together?
Well, I just figured that it'd be an opportunity to meet one-on-one so that we're not in an open forum, so that we can ask questions procedurally, have an open conversation about any questions you might have.
I wouldn't be shy about talking in front of the other commissioners. I think I would learn something from a more robust group.
And so would you want to do that as?
The fear is actually we can't meet with, we have quorum issues. So we'd have to publicly notice the meeting. The public would be able to attend. We could possibly meet in smaller groups. There's no definition around this, but we have to be careful to not have a quorum meet.
I think maybe the issue is that the schedule is so full with, no?
No, the schedule is not that full.
We could do it as a group.
In a meeting, regular meeting time. So there would be an open meeting. It would be on the YouTube, and we would have people that could join us.
That actually might be helpful for the public.
I would actually rather do it in the smaller groups because I think it will invite a little bit more robust conversation rather than being on.
I agree.
Okay.
I would just like to have, I'd like to hear some other thoughts that I'm not that smart a guy, and I like to listen and learn from others.
Yeah, when we were talking about it yesterday with Commissioner Hemer, we talked about a meeting in small groups or individually or whatever. So it has no definition, but I have no problem sitting down with a couple of you, three. We just have to not bump into the quorum so we don't end up having to notice the meeting.
Understood.
I would just make a request that if we could just make sure that as we're coordinating that some of the more experienced commissioners are paired with some of the less experienced commissioners if possible. And we kind of be thoughtful about that.
Laura and I can sit down and we can come up with somewhat of a schedule and find some sunny afternoons coming up when we can go find a nice picnic table somewhere.
Okay. Commissioner Hemer.
Yep. Thank you, Chair. You know, change happens every day in our lives, our community, and in the universe. Without change, life would be boring or even non-existent. But our past, like historic buildings, help tell our story of where we began and what to either repeat or do better in the future. Milwaukie Museum's next Letting Library lecture series entitled Preservation, 3 Experiences, Wednesday, June 1st, 6:30 p.m. inside Letting Library or on Zoom. This program focuses on topics that help preserve our historic places that we endear in our community and our lives. A State Historic Preservation Office representative will discuss the ins and outs on how to list and take advantage of preserving a historic building. Steve Bennett, Milwaukie Museum Records Specialist, will teach home research and how to find those unique stories you may not know about your property. Michael Schmier, a longtime resident and owner of an Oakfield property, will share his thoughts and feelings of living and taking care of a historic home. And we'll also feature a special address by Councilor Lisa Beatty. Thanks to our great partner, City of Milwaukie Letting Library and Willamette Falls Studios, it will be live on Zoom and taped for future viewing on YouTube. Seating is limited inside the Letting Library, so come early to reserve your seat. Please check Milwaukie History Museum Facebook page and the city calendar for more details and links to the event. Thank you.
Thank you, sir. Okay, anybody else?
Yeah, Chair, I would like to just say thank you to staff. I know this meeting wasn't easy, and I know and none of our meetings are easy. And I appreciate everything you guys do. I know it's tough, so thank you. And for, sometimes you have to deal with some difficult things. So thank you for that. And Laura, thank you for always responding to my emails, because we were just talking about, educating people and people being able to ask questions and learn from this. And anytime I've emailed you, you've been responsive. So I really appreciate that. Thank you. I look forward to meeting in the future. Thank you.
Thanks for all you all do. It's amazing to have such a great, dedicated planning commission. I mean, you all do the heavy lift. So really, thank you from the bottom of our hearts.
Good work, everybody. I feel the love. I'm going to continue then with the agenda here, which is for Laura to help us out with a forecast of our future meetings. Laura?
Great, yeah. So June 14th, we are not having a meeting on June 14th. June 28th, we have 2 hearing items now. We have a continuation of the hearing from tonight. And then we also have a community service use for the school, for a sign at the Waldorf School. And then also, we're coming back to have a work session with you all about some of the definitions in the high density zones. I think if you all remember back when we were doing the code implementation work for the comp plan, we had hoped to consolidate the high density residential zones as we were doing the consolidation of the lower density residential zones, but it got really complicated because we've got some complicated definitions. And so we've been putting together an analysis to go through and look at those definitions to start, and then look at how we might be changing the use tables. So there's going to be a work session on that on the 28th. We have lots, the thing that we do have a lot coming up, I will say, is we have a lot of code work coming y'all's way. Again, the code work is never going to end. I think Commissioner Massey, you said something about code work being close to being done a couple of meetings ago. And I thought, oh, you don't know what's coming yet then, sir. So we have lots of kind of complicated code work that's coming up. So you're going to, it should be good. And it's a great opportunity for us to do some really good cleanup on the code. So we'll pick your brains and get some feedback.
This is the bait and switch.
That's right. All right, that's it.
I will take a motion to adjourn.
I don't know, it's only 8:25. Robert, do you have anything that you want to add? No. I'll go ahead and make a motion to adjourn.
Second.
I have a motion to adjourn and seconded. All those in favor, aye?
Aye.
Aye. All right. Meeting adjourned. Thanks, everybody. Good night.
Night, everyone.
Everybody, good night.
I'm going to oppose one of these nights.